All right, we are live. Welcome everyone who is here today for our special webinar on child support and alimony and tax issues. And we're going to help you find out some of the things that you may not know and questions you need to ask. And I am very excited to have special guests with me here today. I'm Lisa Decker, by the way. I am the founder of Divorce Money Matters and DivorceTownUSA.com, and I have some of our esteemed members here with us today to talk with you about this very important and timely topic. We've had some great questions about all of this, and so we're going to start off by introducing our speakers, and then we'll have we'll get into our program. So I want to introduce Sally Fox. There she is. Sally is an attorney, mediator, guardian ad litem, and managing partner at Fox Legal LLC, located in Decatur, Georgia, and serving all metro counties. Some of our folks listening in may be from other areas of the country. She will be specifically referencing Georgia statutes in her presentation, but you will find that many of the principles can apply broadly. So please remember to consult with legal counsel in the state your divorce is located. Today, Sally's going to be discussing critical alimony and child support issues during COVID, including how and when a modification may be needed. So Sally in a minute is going to start us off with that. I also want to introduce James Lepp. James, if you wave to everyone there he is.
All right, and there we go.
And James is also a DivorceTown member. He is a CFP, a certified financial planner, also a CDFA, fellow CDFA. Here you go, James. And that stands for Certified Divorce Financial Analyst, and a registered rep and an investment advisor, with Trinity Financial Planning. Jim will be speaking with us today on the topic of alimony tax issues for the payer and the recipient, and child support, how to assess whether you're getting the full picture. And then we have Stephanie Robbins, who is a licensed clinical social worker with over 20 years of experience working with individuals, couples, and families. Stephanie has a thriving therapy practice in Alpharetta, Georgia, and additionally, she is a parenting educator, speaker, trainer, coordinator, and mediator. Stephanie will help us understand why emotional support is just as important as financial support in divorce, especially during the pandemic. So we've got a lot of great information going to happen for you folks. And you'll also see on the screen here my wonderful assistant, Marcella Kripe, who's going to be in the background helping us with all kinds of things. And so I'm going to get started here. I want to remind you all before we start that for more information about any of our speakers and their specialties or free resources, or to make an appointment, please visit them at DivorceTownUSA.com. All right. If Sally, I'm going to make you the main speaker here, and if our other speakers could reduce their profiles on the page, and we're going to get started. Let's see, Marcella, can you help me out here to just make Sally the big picture? Let me see, I think I can minimize. Oops, I've maximized you. Don't we love technology? We're not hearing you, Marcella. But let's see what we can do here. Okay, we've got, maybe it's the way my screen is showing. All right, folks. If you can see, there we go. That's what we're looking for. And now I am going to mute myself and pull myself out of this. And Sally, we are going to let you start the show here. I've already introduced you. Again, we've got a wonderful lineup of folks. And so this is where we start.
All right. Well, it's great to be seen by everyone. Happy Friday. And thank you to everyone who signed up and who's here to learn about the exciting world of child support and alimony, especially during COVID. I'm Sally Fox. I am a divorce lawyer in Georgia. So when I talk about the law, I'll be talking about Georgia law. So definitely, if you have questions and you're in another state, you want to reach out to a lawyer who practices in that state and not a Google lawyer. So what I'll be talking about today is what happens with an involuntary loss of income, which is something that we have seen happen over and over in the last 6 months after the shutdowns from COVID. And alimony and child support are treated a little bit differently in terms of how we do things if someone loses their income involuntarily. COVID stole your income. What do you do? If you're making child support and alimony payments, the question we've heard the most from people is, do I have to keep making payments? We're going to talk about that and how that works. How can these payments be changed? How can I make sure that I can feed myself and my kids when they're with me and not go to jail on a contempt for not paying support? We're going to talk about how to deal with that, how to make changes, and what you need to know and when you need to do specific things. First and foremost, it is important to know that child support and alimony can be changed or modified in most cases, but they are modified differently. And I think we have a poll here, and I'm not sure if I can't see on where I'm looking if it's gone up or not. But the first poll is just to see what people think about, can you just simply stop paying your alimony or your child support if you lose your job? And the answer to that is no. You cannot simply stop making payments. Repeat, do not simply stop making payments on alimony or child support if you have an involuntary loss of income. Instead, there is a better way to do things. And the first thing you really need to do in a situation like this is call a lawyer. Those of us who work in the family law world understand how these things work and how to deal with them, and can give you really good advice about what to do, not only in terms of what the law lets you do, but how to be creative and work with your ex or your child's other parent so that we can make sure that everybody's getting what they need in the right way. So if you need to modify child support, you have to first show an involuntary loss of income. And what's really important here is that the loss of income has to be involuntary. So you're going to need to be able to produce facts that show that you were fired, that you lost weekly work hours. This is especially something that's going on now with people who are bartenders or who work in restaurants, or as corporations are cutting back a third or a quarter of their workforce. You need to be able to show that you have had some kind of adversity that has caused a loss of income. Then what you need to do is file a petition asking to modify or change your child support in the appropriate county. In Georgia, we serve people in the county where they live. So if your spouse lives in a different county from you, you need to file in your spouse's county. What our statutes say is that when the paperwork has been served on the other parent, either by a sheriff or by a private process server, you can't just email it to them. They have to be served according to law. But when they are served, our law says that payments shall not accrue from the date of service. Now, that doesn't mean that you have them served and you just simply stop making payments. Although I think that you could make that argument that the law allows for that. Our advice to people is to be more conservative and to have the parent served, understand the payments don't build up anymore, and then ask for a temporary hearing. We are not advising clients to simply stop making payments unless they've had a very long talk with a lawyer about what that looks like for them. And we're advising people to be conservative and to pay what they can when they can, so that when you show up for the hearing, you're able to say to the judge, I'm doing everything that I can, please help me. Most of our hearings are remote these days, and I've found that it's actually a great way to practice law. I'm enjoying computer court, to be perfectly honest, but we prepare the same way. The law is the same. It doesn't change the facts. We can work with clients via Zoom or other video conferencing to get prepared. We talk to each other on cell phones during the hearing if we need to. And it's becoming, I think, an efficient way to deal with issues like this. Here's what you need to be able to show. You need to be able to show your income loss was involuntary. You can't quit your job during COVID and then say, I don't want to pay my child support anymore. And you need to show you're looking for work. How do you show you're looking for work? Applications, emails, networking. Simply handing somebody a list of applications you filled out is helpful, but you also need to show that you're being active in your search for work. That can be difficult now. So again, you want to sit and talk with your lawyer about what do we need to show, and how do we make that evidence work for us. If you have other assets, you need to look at them and look at whether or not you can use them in a way that is reasonable to help support your children. There are some parts of the CARES Act and some of the other emergency provisions that have been passed by the Congress about allowing people to take money out of retirement plans without penalties. And you definitely want to talk to a tax preparer or CPA about that, a financial planner, so that you can understand where you're getting money and how you're using it in a way that's best for everyone in your family. You also want to think about how you're spending the money you do have. You may need to make some other lifestyle changes, because if stopping to pay support is the only thing you've changed, you're going to have a problem in a courtroom when you go in and say, I really can't change it. And that's what brings me to a case study that I recently had. We were in court I think it was in June. The father had lost his job. He actually lost his job pre-COVID, but once COVID hit, he was looking for corporate work and he was struggling to find something. He was able to show that he was looking for work, and he continued making child support payments in full to mom every month. Dad also had some bad facts. He had paid off a huge loan of $22,000 in February. He had over $500,000 in retirement assets. He had over $50,000 in cash and savings. He didn't renegotiate his rent or change his lifestyle. And as I said before, he didn't stop making payments to mom. So one thing you want to really sit and talk with your lawyer about is, how can I reshape payments or stop making them? Or how can I continue to support my kids without it hurting me? And I think we have another poll here where I want to know what you guys think, just looking at these facts, who prevailed in this case. And I won't tell you who I represented until we get to the next slide. But this is what a lot of these kinds of cases are looking like when we're dealing with corporate America and people who have lost corporate jobs. Typically, these people have savings, they have retirement plans, they have money they can draw down on. And I don't know if the poll has...
We're at 50-50 right now. Oh, no, now they're saying dad 33 and mom 66.
Okay, all right.
At this point.
Okay. I'm going to move on to the next slide, and I'll let you know what happened. Oh, wait, sorry. The next slide's about alimony. I'll tell you what happened. I represented mom in this case, and dad did not get a change in child support. The court was concerned and bothered by the fact that he was just living the same lifestyle. He hadn't tried to renegotiate his rent. He was still participating in a number of grooming activities that were expensive, that we were able to show. He didn't think that he should have to use any of his retirement to help pay his child support. And the court didn't accept any of that. The court said, no, you're going to pay the exact same amount of child support here. So that was a great day for my client, who was the mom who continued receiving the support that she needed for her kids. But I want to stress that that's not always how it works out. It really does depend on the individual facts in every case and what you're doing and what you're not doing, which is why if you lose your income, you want to go talk to an attorney. All right, that's child support. In Georgia, child support and alimony are handled a little bit differently. Child support is modified in a way that's dealt with specifically in our statutes. Alimony can be modified, and that's support for a spouse as opposed to support for a child. But we don't have that same file the action and have the party served and it shall not accrue. Instead, you need to show how the alimony is structured in your divorce agreement or divorce order. You want to bring in the same kind of proof that you have for child support. Here's how I lost my income. Here's what's going on with my other my other assets and what I'm doing with my lifestyle. And you want to absolutely ask for a hearing as soon as possible so that you can get in front of a judge and get some things changed if you can't work with your former spouse. And I cannot stress enough that being able to work together is going to be the best thing for anyone, especially during COVID, but really at any time, who needs to make changes. The less you can treat someone unkindly during the divorce and after the divorce, the more likely they may be to work with you later on if you need something. And we always try to stress with the clients in our office that, you know, it's really true that you get more flies with honey than you do with vinegar. We can always be aggressive if we need to, but if we can work together, that's certainly better. And in these cases where people are really hurting financially, the times where they've treated each other with kindness, those cases are working out a lot more easily and cheaply than the ones where everybody's still angry. So things to take away. If you have an involuntary loss of income, you need to talk to an experienced family law attorney about how to make changes and about the issue of attorney's fees. In Georgia, the prevailing party in a modification, so the party who wins, can ask to have the other side pay their attorney's fees. And that can be a really useful way to negotiate things. You cannot simply stop paying alimony or child support. My advice to people is to pay what you can and work with your ex if possible, and to sit down and have some real candid conversations about finances with your lawyer and make those decisions together about what you're going to do. You want to be able to show that you're making other lifestyle changes and provide good proof of the need for a change. And you want to look for creative solutions, especially in the alimony space. There are two kinds of alimony in Georgia. There's periodic alimony, pay your ex-spouse $1,000 a month every month until he or she gets remarried. There's lump sum alimony, which is I'm going to pay you $500,000 over 10 years with this amount every month. Sometimes it's changeable, sometimes it isn't, depending upon the kind of alimony. We just had a recent case come down that may have changed how we look at those things, but that's why you want to look for creative solutions. Maybe you can call up your ex and say, hey, can we hold things off and can we come to an agreement about how I'm going to pay you going forward? Or like you might call a landlord and say, hey, can I have a rent abatement for a couple of months while I get back on my feet? So all the more reason to be able to work together and to work with an attorney who is focused on what's going to be best for you and your family going forward. I'm happy to answer questions about these specific issues or other issues related to the wider world of alimony and child support if you have any. And thank you so much for your time.
Sally, that was great. Wonderful information. And we are so proud to have you as a member of DivorceTown because you are a tremendous resource. So anyone needing help in this, absolutely. Anyone needing help in this sector, you feel free to reach out to Sally and see how she can help you. And if it's okay, I'd like to hold questions for the end for our Q&A time. So next up we have, there he is. We're going to bring James on. So Marcella, if you can take care of that for me here. Or do you need me to do that? All right, let's see. Oh, I think I just turned his audio off now. Can you bring James up? James, you might have to turn your audio back on. I may have clicked the wrong thing. Can we hear you? Say hello.
There we go. I think we're good. Okay.
Okay. All right, James, I'm going to let you take this from here. We're going to hear from you about some of the tax implications and financial issues. And welcome to the webinar.
Beautiful. Okay, folks. So good afternoon, everybody. And here's hoping that we all have a wonderful weekend coming up. So my portion of these topics today may seem dry to a portion of attendees, and for that I'm going to apologize up front, and I'll attempt to be as succinct as possible. First item is really the primary driver of the balance in the segment, and that was the Tax Cuts and Jobs Act of 2018. The impact that change to the tax law really took effect at the end of 2018, and it's also relevant to recognize that all those impacts will sunset in 2025 without Congress taking action to renew them. So let me get directly to the elephant in the room, and that's that what had historically been the deductibility of alimony by the payer, and what that means to the conversations that take place. The other side of that coin also is that the person then receiving the alimony payment is no longer required to recognize that income stream as taxable income. So it cut both ways there. One of the benefits of that change is that the concept of taxation and calculations are simplified, right? We're not dealing with different tax breaks and strategies and the impact on different alimony payments, what that means to each individuals. So simplify that a little bit. And ultimately, alimony is now a dollar for dollar reduction of disposable income to the payer, and likewise, dollar for dollar income stream for the ex-spouse receiving those payments. Speaking generally, that change to tax law has benefited the person receiving the payments. It may, for example, affect social programs that alimony recipients qualify for, since their income will appear lower than it would have under the prior laws. For example, if they're not required to report alimony income for health care, their reported income would be lower, and they could potentially get a higher subsidy than would have been the case prior to 2019. Slightly different point, and one that rarely comes up as relates to underpayment. Yes, my tongue's firmly planted in cheek. If both alimony and child support payments are called for by the divorce or separation instrument and the payment is less than the total required, the payments first apply to child support, then to alimony. Another point, cash payments, checks, money orders to a third party on behalf of the spouse under the terms of the divorce or separation instrument can be considered alimony if they otherwise qualify. Excuse me. Those would include payments for medical expenses, housing costs, rent, utilities, etc. Payments are treated as received by the spouse and then paid to the third party. Alimony also includes premiums that must be paid under the divorce or separation instrument for insurance on the payer's life to the extent the spouse owns the policy. I'm going to assume that the attorneys in the room routinely include those products to protect their clients. Conversely, not all payments under divorce or separation instrument are considered alimony. So it doesn't include child support, obviously, non-cash property settlements, payments that are your spouse as part of the community income in accordance with community property statutes and states. Payments to keep up the payer's property or use of the payer's property. In summary, I believe the tax law certainly changed the dynamics of the conversation, removed the psychological aspect of the payer being able to deduct the payment and corresponding calculation of multiple tax rates. Willing to wager that the attorneys here would be able to argue both sides of that coin as pertains to the net effect being positive or negative. But being a financial person, just like to deal with the facts as much as possible. Okay, moving on to child support issues. There's wasn't a bunch of changes resulting from the act. Prior to 2018, fathers were allowed to take dependency exemptions for children, but those exemptions can no longer be used. Parents had previously been able to claim a dependency exemption for each child they supported, which worked like a tax deduction by reducing their taxable income. A person with children under 17 will still be able to claim the child tax credit for $2,000 per child. And if a parent is still supporting the child over 17, they can claim a dependent credit for up to $500. People need to make sure they're taking advantage of these child tax credits since we don't have dependency exemptions anymore. Be aware. Be aware of any terms in the separation and divorce documents that address who can claim those credits and when. For me, the biggest change isn't unique to divorce, yet may be significant to a family with children regardless. The Act made changes to the child's dependent care tax credit, and for the non-CPAs in the room, tax credits are substantially more valuable than deductions come tax time. If you pay someone to take care of your child while you work, for example, you know that the cost of child care can take a big chunk out of your take-home pay. To help offset that cost, you can claim a credit of up to 35% of the amount you paid for child care during the tax year. It's well worth tracking that amount you pay for the care of your child under the age of 13. If you qualify for the maximum 35% credit and you pay $4,000 per year in child care, for example, you can receive up to a $1,400 credit. If your adjusted gross income is over $43,000, however, you may receive a child and dependent care credit equal to 20% of your expenses. You generally must work or be looking for work to take that credit. You cannot take the credit or exclusion if you have no earned income for the year, unless you are a full-time student or are disabled. Instead of diving deep into the various examples at various income levels, the impact of that change to the credit, suffice to say that the value of the credit has become less valuable. It is non-refundable to lower and lower moderate income families. Okay, shifting gears again, let me move the conversation a little bit to the area of financial impact of the tax law change, specifically funding retirement. We heard earlier how the most recent legislation enabled the ability to access retirement accounts to fund living expenses, or in this case, alimony, child support. Most financial advisors would discourage that as much as possible and view that as literally a last ditch effort or last case scenario. Ultimately, getting back to the original tax law change, the Tax Cuts and Jobs Act, it also negatively impacted the recipient of alimony's ability to use those payments as a source of funds for IRA savings. Many people use IRAs as a substantial part of their retirement income strategy. The funds deposited into an IRA must be earned income. And since the Act removed alimony as an income stream for the receiver, it could no longer be used as a source of funds to contribute to IRA savings. For some, this is merely a shell game as they have ready streams of earned income. For others, that change could be significant and impactful. Okay, and then lastly, the last piece was going to get after the hidden income topic. And that can play a role in both aspects related, obviously, to both alimony and child support. Sometimes those submitted documents do not show the whole picture of what the payer parent makes or could be making. This could be for a number of reasons, including they could work for cash, they're not actively looking for a job, are underemployed by only working part-time or in a low-paying job or a lower-paying job than what is considered reasonable given their skills and history, are simply not reporting all their income, or, to be blunt, providing false information. One indicator that information is being withheld may be evidence that their lifestyle doesn't reflect what they say they make. Require financial disclosures. credit card and bank statements will show how much partner is actually spending. Some people resort to hiring a private investigator to collect evidence. It is obviously not an inexpensive option, but if the settlement is substantial enough, the payback is easily offset. Large cash outlays, for example, large home improvement expenses, purchases of large ticket items, may be indicative that there may be unreported or hidden income. If the spouse is a small business owner in a cash-intensive business, some forensic accounting work may be required to gain some clarity. Business tax returns, financial statements, and bank statements frequently bring light to discrepancies, and that make a difference. I spoke with another CDF yesterday, and we were sharing some more stories, and he shared one about a disputed business valuation and after going through all the normal channels, he wound up uncovering a business loan application that had been filed a few months before the divorce process began. The difference between the two numbers were substantial. Certain professions are more prone to this kind of abuse, purely due to their structure, and not intended to cast aspersions on people in these professions. However, they readily provide avenues that some people use to hide money. They could be small practice lawyers, financial advisors, virtually anyone being paid as a contractor versus an employee. And I already mentioned the cash-intensive businesses like car washes, laundromats, for example. I believe that pretty well hits the points I wanted to make today, and thank all of you for your attention.
All right, James, you packed a lot of information in that short time period. Thank you for that. I know that the financials as a financial person can sometimes be dry, so it can be a little tough to spice those up. But there's a lot of really important information that James shared here. So if you have any other financial questions, please feel free to put them in the chat box, and to feel free to reach out to James afterwards, and he can answer more of your questions. Okay, thank you so much, James. Next up, we have our licensed clinical social worker and our very esteemed and valued member of DivorceTown, Stephanie Robbins. And she is going to be speaking about why emotional support is just as important as financial support in divorce, especially during the time of a pandemic. And so, Stephanie, welcome, and I will mute myself here and let you take it away.
Good afternoon, everyone. I'm so honored to be here to speak to you regarding this very important issue. I'd like to talk about the emotional support, how it's just as important as the financial support in the divorce process, as well as during the pandemic. I'd like you to understand there are specific triggers and emotional reactions that people have that might hinder them to make sound decisions about their financial future. I want to give you some tips and strategies on how to manage your emotions and to best express your feelings so that you are able to get the support you need. If people don't get the emotional support during the divorce process and during these financial decisions, it is harder for people to make major decisions about their future. They are unable to negotiate or come up with compromises. Their emotions take over and they're unable to see creative options, or they have problems with moving forward or letting go. With these emotions, they're not able to think logically or rationally, and so not able to stick with the facts and then get bogged down by their emotions. So when people are so emotional and not able to really look forward and hear, they might not be able to hear their attorney or their financials professionals on creative options or things that are their best interest for their future. During an emotional divorce, we have to process all sorts of different emotions during the divorce process. Typically, people or the spouses go through the divorce psychological stages differently. Typically, I've seen there's an initiator. That is the person who decides that they're wanting the divorce and verbalizes it to their spouse. And the spouse that gets on the other side is the responder, or I call it the blindsider. I've seen in my practice how maybe couples have talked about divorce, but when it becomes real and one person expresses exactly what they're wanting, the person that feels blindsided knows that their relationship was in trouble, but really didn't think it was going to go to this as far as to get divorced. So the blindsider might have feelings of denial or in shock. The initiator might have already processed the divorce many years before, sometimes 3 to 4 years before. So they seem very systematic and able to be more clear with their emotions going through the divorce process. During the divorce process, there are a whole bunch of emotions such as insecurity, self-doubt, confusion, having resentments towards the other, anger, and then the grief and loss. Divorce has been compared to a death, and I call it a living death. There are certain triggers that cause people to have more emotional reactions during the divorce process that might hinder them moving forward and coming up with settlement agreements. The first one is going through marital separation, division of the household. When one spouse has to decide if they're going to stay or move out, the questions come up: who's going to keep the home? How are we going to afford the home? Do we need to sell the home? How are we going to manage financially two households? And then also looking at places for the kids, keeping the kids in the same school district, wanting to consider their friends, how far of a distance from the other parent. When you have to get separate, when you get to that, when you separate, that is the time that divorce becomes more real. And it's also when people start talking to their kids about the divorce. So not only are they managing their own emotions, but then they have to manage their children's emotions along with that. Going through the separation causes feelings of loss of control. The life that they thought they had and the dreams are totally taken away from them. Causes people to have some fear of their future, uncertainty of how they're going to survive, how they're going to take care of their kids, and also will cause some people to have lots of problems of letting things go and causes more anger. The change of financial situation during divorce, people are accustomed to having probably 2 incomes now to 1. One person may have been the stay-at-home person to take care of the children. Now they're having to look for a job or go back to school. Also, one person in the household might have been in charge of all the finances, paying all the bills, managing all the accounts, and going through the divorce, the other spouse is needing to get financial information to their financial professional or their attorney. They might not know passwords of the different accounts. So that can cause some anxiety and some feelings of insecurity, not knowing this information. That also come up that are triggers emotionally is health insurance. If going through a divorce, you might have had health insurance under your spouse, and then now you're going to have to find your own health insurance. And people with certain medical conditions or chronic medical conditions, this can be very frightening, having to find outside insurance or finding jobs that have that. During the alimony and child support can also cause a lot of triggers. Alimony is based on several factors, and Sally can, or any attorney can explain a little bit more. It can be based on the length of marriage, standard of living during the marriage, and the earning capacity of the spouse that's been staying at home. During discussions about alimony, a spouse might feel going through an economic insecurity, feel the need for survival. Maybe they felt that they don't have enough income or have enough saved away to help them for many years. This can cause some resentments for the spouse who's having to pay the alimony, and then some entitlements of the spouse who believes that they should be getting a certain amount for a certain amount of time. A lot of times there's something that's called tribal warfare. This is when spouses have their own communities, their friends, neighbors, and families. They kind of get in their teams and they start getting advice from other people. And they might hear that their neighbor got $15,000 a month in alimony. And so the person feels that they might be entitled for the same, but people are not understanding other people's individual situations and not really fully reading or understanding what their professionals are saying to them about how their situation differs. On child support, each state has their own way of determining child support. I know here in Georgia, there's based on a formula. This can cause a lot of people to have some misconceptions about child support and how it's allocated. Some people believe that child support should be given just directly to the kids, and others believe that the child support is given to the spouse and the spouse is using it for themselves. This is where areas of control come in, where people are wanting to know where the money is going towards. The spouse that is wanting, the spouse that is paying the child support feels that the figure might be too high, or the spouse that's receiving might feel the figure is too low. This causes emotionally charged. A lot of people that are in a high conflict divorce, they will fight over child support, and also cause sometimes fighting over primary custody of living where the kids will be with that. Other people sometimes will use child support as a way of controlling. They are supposed to have child support due in a certain month, a certain time of the month, at certain times. I know I have had clients who will pay child support at 11:59 on the day it's due, just to hurt their spouse, their ex-spouse, or to play games. Again, that's kind of a control thing because they have a resentment of having to pay the child support. The emotional divorce during the pandemic, just during in general about the pandemic, people are having fears of uncertainty, loss, fear of getting sick. They might have a parent or a grandparent in the home, or a child that's high risk. Also during the pandemic, there have been a lot of people with different job changes and unemployment, which has been causing changes in child support modifications, as well as sometimes custody modifications, where there might be a spouse, a parent who has been working and not been home, been working, traveling, and now they're home and available with the kids and they want more time. Or when spouse has a high risk job where they're exposed to COVID, and the other parent doesn't want that parent to come home and bring it to the children, so then they're wanting to take care of the children so that the kids don't get exposed. With the pandemic, again, there's lots of feelings of fear and uncertainty and loss and confusion. Some tips and strategies to how to get the emotional support you need to manage your emotional and financial divorce is, first, always be kind. Try to communicate with your ex first. Pick your battles. Have some compassion, especially if your ex has had some sort of job change or has had change in adjusting to the pandemic. Please speak up. Do not assume anything. Your professionals know that you're going through this process. If you are unsure about something they're saying, get clarification. Ask them to explain things more. Don't assume that they can read your mind about how you're feeling. Or if you're going to some of the meetings or having talks with your attorney or your financial professional, you might show as anxious. Explain why. And it could be that you might not be aware of your own financial situation, or that you have some insecurities. I always recommend people having a friend or a family member close by to help them, especially when talking to their attorney or financial professional. It's another pair of eyes and ears to help support. A lot of times the information will just go over people's heads. People will have so much information going on, it's overload. So having a friend or family member there to hear might be helpful. Also to help with the emotions, to help calm you down. It's best to communicate your needs and wants very clearly. If you're having a hard time expressing verbally about what you're needing, it might be best to write things down, send emails, or bring lists to these meetings. I help my clients a lot of times get organized. I found that if their emotions are all over the place, if they can start getting organized with just things in their house, or even with looking at their financials, getting a notebook, start having a place where you have all your bills that are due, what your counts are about having a budget worksheet, making lists, that all can help ease some of the anxiety and you feel a little bit more control. Educating and reading yourself, reading about things that can help you too. The more knowledge you have, the more secure you'll feel. And I want you to understand that your feelings are like waves. You're going through the grief process, which are, feeling of shock, maybe denial. You bargain, negotiate, trying to, if I do this different, if I do that different, then going through like some sort of depression or sadness, and then finally getting to the acceptance stage. However, you can go through these stages throughout the divorce process and after, and you might not realize that you might be coping very well, and then all of a sudden something hits you, a trigger, and then it takes you all back through all the emotions. So be kind to yourself, don't expect too much, and to seek out support, emotional support, especially from healthy friends. Talk to people that are in good situations, people who've had good divorces, who have good communication with their exes. Work with, have family members that are close by, may want to seek out places of worship. That might be a good support. There's lots of divorce groups out there. Right now during the pandemic, a lot of the groups are online. It's really great to connect with others, especially when you feel isolated. And lastly, speak with a divorce coach or therapist. A divorce coach is a licensed mental health professional who has specific training in divorce and working with individuals, couples, and families. When you need to speak to a professional, typically is when you have so many issues of anger and resentment and just an inability to let go. You're not able to really compromise, make negotiations, to really hear your professionals. So if you go and process your feelings and understand where they're coming from and helping you to let go of that anger, then you're able to make better decisions about your financial future. And that's all I have to talk about today. I'm happy to answer any questions and to provide any support that you need. Thank you.
Thank you, Stephanie. That was wonderful. You provided excellent information, a lot of great tips there, because the pandemic that we're all living through and figuring our way through here has certainly added a lot of complexity to things that are already complex and difficult in people's lives. So thank you so much for your expertise, and we appreciate you being here today. I'm going to bring everybody back up now, or I'm going to ask Marcella too. She's got the controls here, I hope. Or if you need to turn yourself back on, there we go. And Marcella, if you would go through the chat box, I know you had some questions from the beginning here, and just let us know what the questions are. We'll see if we can answer those for some folks.
Sure. We have two very good and specific questions. One of them was, if an individual obtains a modification ruling due to lost income due to the reduction in partial payments, do the reduction in partial payments need to be made up in future payments?
I think we're going to pose that to Sally.
So I'll take that one. I saw that one. That's a great question. So let me say this about child support and modifications. Modifications are forward-looking, so they're going to start as of the date of the modification. That's why it's important to try and get a temporary hearing as soon as possible, or some kind of agreement with your former spouse. And that's why that shall not accrue language is important. We do not go backwards to modify. So if you had a payment due in February and a payment due in March, and you didn't get the spouse served until April, certainly those February and March payments are going to be due. In general, what I tell people is that your child support is due until it's changed. And unless you live in a box on the side of the road and you can't sell the box, you need to find a way to make those payments. And so we can figure out a way to add a certain portion of each payment per month so that you're not looking at a huge chunk of money coming out at once. I am always happy to look for creative solutions to things, but in general, modifications are forward-looking, and we don't modify backwards. So that's why getting that person served, getting it filed, and getting them served.
What about if, Sally, a follow-up question to that? What if they're situation changes in the future. We hope COVID isn't with us forever. So we get forward a year or so, and now they're back to making their regular income. At what point can you remodify, ask for another modification? And does the income have to be a certain percentage? Is there a 10, 15% margin that it has to change? Or has COVID changed that right now?
No, so yes, you can make changes. Child support is subject to modification. Generally, it's every 2 years, unless there is and even then, you have to show a substantial change in income. So with COVID and with emergencies and involuntary loss of income, you don't have to have that 2-year wait. But in general, if you're just going to modify or make a change, we look at it in 2-year sections. That's a very broad outline of it. But if you're the one who had the amount lowered due to COVID, I might not suggest you go back and ask to pay more. You can voluntarily do that if you want to. If you're the person, the person receiving the funds, and you see that the payor spouse has a new job, is making more money, some of those things about hidden income and what we look for that we heard about from James, I think are useful things to look at. You have to be able to show that there's been a substantial and material change in income and finances that affects the children. So somebody who's living large, buying new cars, putting cash out all over the place, those are things you're going to want to go back in and say, hey, this person has more money and let's talk about what they should be paying. I hope that answers your question.
It did. I just a little bit more clarification on that. When you say substantial, is there a certain percentage that we generally look at? No,
it's fact specific. It's substantial, and it has to affect the welfare of the children. And depending upon who I represent, substantial might mean one thing in one case and something else in another. So
perspective is everything, right?
That's right. No, it's very fact specific, and it depends on the case and what's going on.
Okay, always the best interest of the children is what we're looking for. So that's our most important thing here. Okay, Marcella, do you have another question for us? Thank you.
We do. We have one more question. Thank you. Someone asked, and this is a good question, can health insurance be part of alimony?
The answer is yes, as long as in the instrument it is defined as an expectation, right? So if the instrument states that the payor will do that, then the answer is yes.
And I think there needs to be a little clarification around that. Go ahead, Sally. I want to.
Well, and I'll add to that a lot of times what we do with the issue of health insurance and how am I going to pay for health insurance is I suggest that clients try and figure out what it would cost, whether they're going through the Affordable Care Act or a private, another kind of private health insurance provider. And I know there's a number of good health insurance providers in this group. I encourage them to go talk to those people and find out what the premium cost would be. And we can add that into whatever a monthly alimony payment might be. We can work with that if we're negotiating in terms of a property settlement. There are a lot of ways we can work with what that monthly cost is for someone and work it into the whole property settlement. I think James is going to talk more about the tax implications there, but what we're thinking about in terms of the settlement and the divorce process is getting you what you need on a monthly basis to be able to afford what might have at least felt like it was free during your marriage, even if it wasn't.
Yes, and I'll follow up to that. A little clarification is that, for this particular question, was the person looking to get their health insurance paid by the spouse in addition to alimony, or were they looking to incorporate the amount of health insurance into alimony? And that can be a bit tricky there. So it's something that has to be looked at very clearly because you also may have changes in your health insurance along the way, and you want to have some latitude for yourself to be able to deal with that. So every situation needs to be looked at differently. But again, having the right professionals take a look at all of these things from all angles. And I want to say here that, this is what we ideally love to see in a divorce. You start out with what's called the three-legged stool. You have your legal, your financial, and your emotional support. And when you've got those three anchors, then you can add in all the ancillary questions, whether it's health insurance. We've got Bob Smith on the call today. He does a great job with our clients in answering those kinds of questions. You may have to get qualified for a new mortgage. So you're going to need a mortgage broker. You may need someone to come in and assess the value of the house, be that an appraiser or a realtor. And so it's not just as simple as it seems on the surface many times. We want you to have all the answers to all the complexities of your divorce. And even the simplest of divorces have complexities, folks. They really, really do. So again, we want to make sure that you have had all your questions answered. Marcella, I'm just going to jump in here and ask you if we've gotten every question answered. Anything last minute here?
I think those are all the ones that I saw. If anyone has any other ones, just pop them back in there. I briefly got kicked out and came back in. So just in case I missed anyone, please feel free to let me know. Unfortunately, I'm only human. I hate that. I hate that.
I think of Marcella as superhuman, I have to. But we are having some technology glitches. I see some of us popping in and out of the call, and that's just typical for life in the age of COVID. So this has been wonderful, you guys, and thank you again for your support, for all of our listeners out there. We've got a screen up here. Let me see if I can put our speakers down so we can see the last slide here. If you guys can reduce yourself, turn your videos off for a minute. And there we all are. If you want to reach out to any of the presenters here, you can find us all at DivorceTownUSA.com or at any of our websites. But we are grateful that you've attended today, and we look forward to serving you with any of your divorce needs. And thank you so much to Sally Fox, to James Lepp, and to Stephanie Robbins. You are appreciated. And Marcella, thank you for always controlling all the things in the background that keep everything working so well. Again, thank you, folks. We're here for you if you need more assistance. Take care now.